want to mention the Cable Commission. I've been to 2 meetings since the last time we all met. They met on January 26th, and they met today at 4 o'clock. So I've been already for 2.5 hours in meeting today, because at 5 o'clock they had to adjourn to a different room, and we're still going on, and I had to come here for the Township Board meeting. They've been struggling with the Comcast transfer of control of our area to Great Land Communications, a new company that's been created with Charter actually operating the TV services. And tonight they were getting ready, hopefully, to make some sort of recommendation to us. We have it on our agenda later on, and I don't know what that recommendation is because I had to leave early. So we'll all find out soon. I know one of the commissioners is sitting out there, and I'm sure that our director, Deb Guthrie, will be here by the time we get to it on our agenda. It's important that we take some sort of action by February 27th. That's the current deadline that we have for getting involved in that process, even if it's to decide not to do something. So we were discussing it tonight, and we'd be, I assume, acting on it in 2 weeks.
Thank you for the opportunity to talk to you this evening about important changes that are coming to the cable communications business in Meridian Township, as well as over 400 other Michigan communities. Comcast cable systems in Michigan and several other states in the Midwest and South are going to come under the ownership of a new company, temporarily named Midwest Cable, and ultimately, once the transaction is completed, to renamed Great Land Connections. Great Land Connections will be a brand new, independent, publicly traded company. On day one, Great Land will serve 2.5 million customers that are legacy from Comcast systems concentrated in the Midwest and South, with almost half of them here in Michigan. Great Land will be the nation's 5th largest cable TV provider. While we'll be a brand new company, we'll retain existing Comcast cable systems, assets, employees, and will have approximately $4.5 billion in annual revenues. To make the transition from Comcast to Great Land seamless to our customers, there will be a transitional service agreement between Comcast and Great Land Connections. This is customary arrangement in the cable industry. Great Land Connections will contract with Charter Communications to provide some support services and will benefit from Charter's market presence to secure cable programming at advantageous pricing. Through the service agreement and 1/3 ownership interest, Charter Communications will have a vested interest in helping to ensure the success of Great Land Connections. I'd also like to highlight that Great Lands will be led by a very experienced management team, headed by President and CEO Michael Wilner, a highly respected 40-year cable veteran who was co-founder and CEO of Insight Cable. We're very pleased to have had Keith Hall, the Executive Vice President of Corporate Affairs for Great Land, join us earlier today at the Meridian Cable Commission meeting. The transition to Great Land Connections will provide greater focus on our state and local markets. Service and reliability will be enhanced for both our residential and business customers. Much may be discussed about the role of the township in the transfer of the franchise from Comcast to Great Land Connections. I have provided you with information earlier today about the financial well-being of the new company and the current state law. We are encouraged by the actions of the Meridian Cable Commission this evening, unanimously reversing the actions taken at their special meeting last week and voting to recommend approval of the franchise transfer with narrow stipulations. We're here tonight to answer any questions you may have. Thank you.
Thank you. Last summer, Meridian Township received a transfer of control request from Comcast to Midwest Cable. The transfer requires Meridian Township to consider many factors, including whether they have the ability to comply with its obligations in respect to the use of the rights of way, as well as its ability to provide cable services. Since that time, the Township Board approved and hired financial consultants Ashpon Skolko and Front Range Consulting to assist in reviewing the transaction and in obtaining a complete and accurate application so that the township can act. That was part of a consortium that Meridian Township was involved with many communities in Minnesota, as well as Southfield in Michigan. We do not think that we have ever received a complete application request from Comcast, and we have requested several times for information as it relates to addressing the Meridian Township Code of Ordinances, and we do not believe that we've received that information. Today, the Cable Commission recommended approval with conditions as it relates to the transfer only, and excluding conditions relating to the franchise renewal, supporting staff's recommendation in the memo that's before you today. The transaction request in Meridian Township isn't simple. There's several federal, state, and local regulatory factors that apply here. And so therefore, legal counsel is here to present the authority that Meridian Township has to review the transaction, why a review is important, and options the board can take. With that, I want to introduce Meridian Township's telecom legal representatives who Meridian Township retained back in 2010 when we had the Meridian Dearborn case, to which we won in federal district court. And so I would like to introduce Mike Watza from the Kitch Law Firm out of Detroit, and Joe Van Eaton with BBK out of Washington, D.C.
I'm Joe Van Eaton. This is Mike Watza. I'm going to go over 4 issues. First, what's your authority to review this transaction? Where you are in the franchise process? What your options are for dealing with the transfer application? And then how you may want to consider moving forward from here, and then, of course, take your questions. Before I get started in that, let me just remind everybody what this transaction is. Comcast, or a subsidiary of Comcast, now provides cable service here in the township. Comcast is merging with Time Warner. And as part of the Time Warner transaction, Comcast agreed to spin off a number of systems in the Midwest to Charter Communications and to a new company called Midwest Cable, which will eventually become Great Land Connections. What Comcast filed for here was an application asking you to approve the transfer to Great Land Connections. Great Land Connections, in turn, will contract with Charter, which will provide many critical operational and management functions for the system. For example, a lot of the customer service activities, telephone answering, billing, marketing, will be done by Charter. And Charter has told its investors that this effectively gives it operational control over large portions of the Midwest. So you're going to have Comcast with a lot of control over most of the other country, but in the Midwest, you'll see Great Land and Charter essentially providing services. That's the transaction that's in front of you. And it's led to reviews not only here, but in a number of other communities. So the first question is, what's your authority to review? Under the Federal Cable Act, there is a federal level of review of a transaction like this, but there's also local level review. And localities are responsible for deciding individually whether the transaction should be approved or not. And the only big case I know of in transfers actually involved a community in California that said no when every other community said yes, and the court said it doesn't matter what everyone else does. It's up to each community to decide whether the transfer meets local requirements. So here you have a strong ordinance, and it's cited in the document that's attachment D in your packet, Chapter 70, Section 70-57, which describes what has to happen if someone wants to obtain approval of a transfer. And that's been the guiding document that we've been looking at along with Ashpond, Skolko, and along with staff in deciding how to treat the transfer. Now, Comcast has contended, and it has contended this from the beginning, that that transfer provision is no longer valid. That state law, PA 480, effectively unilaterally modified every franchise and every ordinance so that only the conditions in PA 480 related to transfer, and there really aren't any, are applicable. And that's sort of been their position, that they've submitted an application, but they've said, we really don't have to do this at all because of PA 480. The problem with that position is at least 2 courts have rejected it effectively. One in a case involving you, the court said PA 480 can't be read to modify any of the PEG provisions in a franchise because federal law prevents that. And obviously, as you all know, you have federal law trumps state law, state constitution trumps state law tends to trump local law. That's the basic rules of civics, right? So the court said, we'll read 480 to allow Meridian Township to continue to enforce its PEG provisions in its franchise, notwithstanding PA 480. PA 480 has to be read consistent with federal law. And then in a case involving Detroit, the court said under federal law, the transfer provisions are not unilaterally modified. Provisions in a franchise aren't unilaterally modified. That would include the transfer provisions and any other provisions in a franchise. That would be inconsistent with federal law. And in addition, in that same case, the Detroit case, a serious constitutional issue was raised and reflected in a opinion of the Attorney General, who effectively said, because localities are constitutionally the franchising authorities in Michigan, franchising authorities have the right to say no when someone applies for a franchise. To me, while this certainly hasn't been decided by any court, that also implies they may have a right to say no when someone applies to be the transferee, to be the new franchisee. So effectively, in our view, and I think Mike shares this view very strongly, we think your ordinance remains a source of authority for you, and you do have authority to review this transaction. Now, I'm clearly not going to say that's resolved as a matter of law. I don't think Comcast can say that either. They clearly dispute that view. All I can tell you is they just settled the Detroit case and paid Detroit about $26.5 million. And in most cases, in my experience, you don't settle unless there's at least a colorable claim. So I think going forward, you can assume you at least have a good claim that you have authority to review this transaction. So then the question is, where are you in the transfer process? Now, federal law has a transfer provision that says you have 120 days from submission of a complete application to say yes or no to a transfer. If you do nothing, the transfer is deemed granted. So no action is equivalent to yes. Okay? Now, it's long been we've gone 120 days long past when the application was filed. But there was a dispute as to whether it was complete. What Comcast has agreed is that if this locality acts on or before February 27th, it won't argue that you acted too late. After February 27th, it certainly has the right to argue you've deemed this granted. Okay. They've also reserved, obviously, their state law arguments, but February 27th is effectively your deadline for action under that Comcast agreement. It could be extended with Comcast consent, but February 27th is right now the deadline. So in preparation for the deadline, you did a financial analysis, but you also did some other things that federal law suggests you should do. You looked at what the company contract said and whether it looked as though this company would be able to comply going forward with its obligations. And in the report, again in attachment D, there were 4 or 5 bases identified that would support a denial. Again, Comcast would dispute all of these, but I think they're at least substantive and meaningful. And one is the financial issue. The financial data to us doesn't say, we're not saying the company will fail. What we are saying is the company failed to show it's going to be in a position to perform without substantially increasing either prices, reducing services, or taking other action that would be harmful to the township or its residents. And that, to us, is sort of what a locality should be thinking of. It's not here to mimic Wall Street and say, is this a good investment or not a good investment? It's here to say, is this transfer in the public interest from the perspective of the subscriber and the citizens? The second was, did they cooperate and provide the information required by the local ordinance? And the answer to that was no. One of the reasons you're getting this so late is because literally people have been working to get data from the company since last April. We were still getting data and analyses last week. The third element is technical qualifications. This is an unusual transaction in the sense that Great Land won't be, as Comcast effectively is, providing the whole kit and caboodle of the operation. Charter will be doing a large functional portion of the operation. When I look at that, I ask, for example, what happens, or how can you be sure the company is going to be able to provide adequate customer service? Do they have enough of a lever over Charter to get rapid corrections to customer service problems? We all know Charter's reputation in this area based on J.D. Power's ratings. When I look at the Charter Services Agreement, I don't see that authority. That doesn't mean it can't be obtained. It doesn't mean the company won't exercise it, but I don't see that sort of important ability that I think is key to technical qualifications. The last element, or the last few elements in the report, are effectively what is being transferred. That's the question. What are the terms and conditions of the transfer? One of the interesting things here is I wouldn't know today exactly what Great Land is accepting. Are they willing to comply with franchise conditions in your franchise, for example, related to transport of PEG signals? There's a large institutional network provision in your franchise that requires the company to transport PEG signals from point to point, for example. I don't know whether they agree. I think with Comcast, with the entity you have now, because of the court decision, I don't think there's any question but that Comcast remains bound by those obligations. I don't know what Great Land would be accepting. Presumably, we could agree what the terms are, but I think a basic condition of a transfer when you're granting someone an enormous benefit as you are to Comcast is to understand what you're getting, what the terms and conditions are. So that you'll see in Attachment B as a basis for finding a denial. That doesn't mean you should deny or that that's the best course, and that's not the staff recommendation. So let me go over what your options are and sort of what the consequences are. One option is to deny, and obviously if that would happen, you would face litigation, potentially. You also would be in a position of being one of the few communities that have not approved this transaction. Now, most of the communities that have approved this have done it pursuant to agreements which actually contain terms and conditions defining that were intended to protect against some of the perceived harms of the transaction. That's true not just here, but in other places like Kentucky, Minnesota. Some of the communities here in Michigan have deals as well. Some of the communities I work with in the East Coast have deals as well dealing with this transfer. But if you deny and you face litigation, there wouldn't be many communities in the same position. That shouldn't bother you. You were in the same position with respect to the PEG litigation that upheld your PEG channels, and you succeeded there. And I don't think it makes a difference in terms of the legal merits of your position, but it is something you need to understand. The advantage, of course, of saying no is it forces the company to deal with you. The company must confront your issues, they must deal with you, and they will have an incentive to deal in good faith to resolve issues surrounding the transaction. The other option you have is to approve unconditionally. The problem with approving unconditionally is you really don't know what you're getting. So let me just emphasize that right now, for example, you don't pay anything for PEG transport to send signals upstream. But Great Land isn't committing that it will continue to carry PEG signals upstream for no charge. You could end up seeing it take over the transaction and say under PA 480 we don't have to do that. You need to start paying. That could happen the minute the transaction closes under the existing franchise, absent a good condition in the transfer. You right now get a 0% PEG fee, but Comcast provides other significant benefits to the community that led AT&T agree to pay a 3.36% PEG fee. So what happens after this deal? Does Great Land agree that it will pay a PEG fee? Will it agree not to pay a PEG fee? Will it take the position that from now till forever, you effectively get zero. If that happens, you can expect your AT&T fee to disappear. You might see charges suddenly being taken from the franchise fee for free services to schools. You just don't know. So there could be real adverse consequences from an unconditional approval. And from a legal standpoint, what worries me is if you unconditionally approve, and Comcast has been saying PA 480 is all we agree to, have you set yourself up for a waiver argument that you essentially bought into their position? That worries me. The third element is to let time go by, do nothing, and have it deemed granted. Excuse me. That's certainly a possibility, but I think it has a lot of the same consequences as the unconditional approval, although I suspect the waiver arguments are a little bit weaker if you do nothing. And last, you could do what most communities have done, which is approve subject to conditions. But by approve subject to conditions, it has to be agreed conditions. It doesn't do much good to adopt or willy-nilly a set of conditions that Comcast won't agree to. They have to be agreed to by good faith negotiations between the parties. And effectively the recommendation you have from your commission and from your staff is that you move forward in that direction. And what we would need from you effectively is authority to move forward as staff and outside counsel to attempt to reach agreement on conditions. Now, I will say it does assume good faith on both parties, and it assumes that the conditions can be meaningful. It will not be enough, obviously, for Comcast to say, we'll comply with PA 480, because that means nothing. We have to understand what the deals are. But if it moves forward as it has in some other communities and negotiates in good faith, there's a possibility that we will be able to report back to you with a deal in time for you to take action at your next meeting, which will be the last meeting before the February 27th deadline. That would be February 17th. So that's my report. I'll open up to questions, except one more thing I should add. While the condition from the commission was approval with conditions limited to the transfer, the commission did not prohibit us from discussing other issues. With your approval, we'd like to also potentially discuss renewal issues with the company. Why? Because it's cost effective to do it. Your franchise expires in about 3 months anyway, and there's no reason to kick that can down the road and have a dispute about renewal and what the public law means about your right to reject franchise if we can reach a conditional agreement with Comcast. So we think it makes sense to also try to deal with those issues as well. But obviously, from the commission standpoint, if we reach good transfer conditions or conditions related to transfer only, that would be a basis on which they'd recommend approval. Are there any further questions, or Mike, do you have any additions?
I don't think so, John.
Yes.
Yes, Treasurer Brixey.
What are some of the conditions that we'd be looking for besides making sure that we don't have to pay for the PEG fee, PEG charges, and that we get our PEG fees?
Well, we have a pretty actually extensive list that I've been working on with other communities. They would be warranties I would look for certainly an acceptance of the terms of the existing franchise, for example, so that we know what's going to be in place as long as that franchise remains in place, what's going to happen with respect to that and other other franchise requirements. I'd like to get a condition that that they warrant that based on their own projections, they're not going, the cost of the transaction won't drive them to increase rates or reduce services in the community. Those are the sorts of issues I'd like to address. As some of the things that were raised by the reports we got, some of the concerns we had about the ability to perform, I'd like to see them essentially say, we promise you and we'll be able to warrant that we can do those things. And if we can't, then it will be actionable by you.
So I remember hearing back at some legislative update or that there are some changes in the industry that are requiring installation of some quite unsightly equipment in the right-of-way. Is that anything that is related to this, or?
Mike, do you?
I think I can. I've been counseling you folks about those issues. That is not related.
It's a separate issue.
To this issue.
Okay,
So
good.
think the other
Glad to
two-
hear that.
Okay. Yes.
Yes, Trustee Feenstra.
Well, if I understand you correctly, you, with your expertise, are recommending that we approve with conditions? Is that your recommendation?
That's not mine, that's the recommendation, I think, of the commission, is it?
You didn't get it right, what we had voted on. I think you should listen to the recording or the minutes when they're typed up.
Could you come
Here's
up to
the recommendation
Could you come up to
is,
the microphone and make your comments? Then we can really hear you.
yeah, if we can look at
Thank you.
I think the Cable Commission earlier today made a recommendation for approval upon condition as it relates to the transfer only, and that the franchise, refranchise process is separate from the transfer. And just to clarify what Joe was saying earlier, which I think may have led to a little bit of confusion, was that Joe was recommending that the township board give approval for staff to move forward on both of those, not that they necessarily are tied to one another. And staff has actually been looking at the franchise renewal process since Comcast asked for a franchise renewal in October of 2013. So that's not a new thing that we're doing. It's something that we would like to wrap up and expedite. It expires July 31st, so it's going to have to be done anyways. It doesn't tie in the transfer per se, if that makes any sense.
Well, and it's very natural to roll in common issues. Your renewal, the transfer, all relates to your relationship with Comcast. Your commission did agree that the conditions for the transfer should be limited to the issues of the transfer, and that's correct, and I think that's what one of your commissioners was commenting on. But I also hear from time to time about legal fees and things like that. So in the interest of conserving resources, yours, our recommendation is, let's also talk with Comcast about the renewal as we spend the next week or so with them, hopefully, having serious negotiations about the transfer. But let's get the renewal done as well, because candidly, the law is not as clear as anyone would like it. But PA 480 has drawn a bit of a circle around Michigan and other states like it in terms of what you really can fight for on a renewal. Arguably, I never take that position in a legal brief, but I'm just trying to talk with you about it. And so it's not the kind of renewal maybe you did 10 years ago where you sit down for 6 months and you really hammer away at all these various issues. I think the renewal can be done fairly quickly. The issues we've looked at and talked about, that staff's looking for, and the transfer as well. It's just an issue of resources.
Yeah, Treasurer Brixey, did you have
Trustee Scales actually hasn't spoken yet. I think it would be proper to have him speak first.
a Trustee Scales?
I have trust in staff, but what I don't have trust in is us sitting up here negotiating and discussing our strategy on live TV. So I trust the staff, I trust the commission, and I trust the lawyers to move forward and do what's in our best interest. I do not agree that we should be sitting here discussing our negotiation strategy on Comcast's TV.
Yes. The manager has some comments about this. Let's let him.
We do also, at the end of the end of the right the table to the right here, have Trustee Stika, who's a member of the Cable Commission as well. So, okay. So
You show up at meetings.
Well, I'm trying to get straight because as you know, from this meeting, I never was there for the very end. What exactly was approved today by the commission? What direction was it?
The Cable Commission passed a motion after a fair amount of discussion recommending approval with conditions related to the transfer only and excluding conditions related to franchise renewal.
Okay, but were there any specific conditions or just this general statement?
There is a list of...
I have two different lists. I have an original list of 7 that was put together by our staff, and I have a longer list of 28 that combined that with broader conditions. So none of these were like circled or recommended to this board? It was just...
No. There was simply the idea of talking about those conditions. You've got them. Candidly, the renewal conditions that we've talked about, and Comcast knows about it, are on that list as well,
Yeah, I understand that.
so.
Yes, trustee Feenstra.
Well, our attorney's recommendations made sense to me. I think we should follow our attorney's recommendation. I think it makes sense to consider both the transfer issues and the renewal issues. And I suspect, well, I assume we will have some kind of motion for us to pass at our next meeting. And I am very much guided by our attorney's advice and the advice of our Director of Communications.
Thank you. And I agree. I'll take this up at our next meeting. So I'd like to go on to 13D. Yes, Clerk Dreyfus.
Thank you. Just a quick comment. Would we possibly have to break into a closed session at the next meeting if the motion or its complexity requires us to discuss this further so that we're not discussing our confidential legal strategy in public? I'm just putting that out there as a possibility, even though we will have to take action at the next meeting.
I think that's a question
measure-
that maybe
the
our
manager
attorneys
wants to
should
put in a
answer.
word.
I think we reached a point this evening where we ought to stop. I agree with Trustee Scales, and I think some other people are thinking the same thing. I think we have enough information. If I could just speak to the issue for just a minute. I think this is a really important process we're going down, but I personally, I hope I speak for the board, I don't want Meridian Township to become an island in Michigan where we're the ones that are just out there pushing an envelope that maybe we don't need to be pushing. I think we should do what you've stated this evening, sit down and negotiate in fair process with the end goal to reach an agreement with Comcast. I don't think anyone in this room wants to spend the kind of money it would take to litigate this issue. And I think we ought to turn it over to you, see where we get, and to answer your question, Mr. Clerk, I think that would be answered on the 17th at the next meeting, depending upon where we're at in the next 2 weeks, whether we would need a closed session or not. But for the purposes of tonight, I think we ought to move on.
Yes, trustee Steiger, one
Just
more.
a real quick summary, and I agree with that, but throughout the discussions that I've sat through that the commission has done, I've kept several points in mind that I think are something to keep in mind, and that is, in the end, what we want out of this, talk about the transfer, and then later on, the franchise, so two different things, but is we want reliable service at a reasonable cost with wide choices, and that includes all of our PEG services to this township and our school districts and our libraries. That's what we want, and that's what we need to keep in mind.
Thank you. Yes, trustee Feenstra.
Well, PA 480 was a rotten law. The legislature never should have passed it, but I guess the lobbying influence of AT&T, et cetera, got it passed. And once it passed, I noticed we started getting bills from Comcast that we never got before. So I hope that in our negotiations, we can reverse some of that. And I don't think we have to, I mean, yeah, Comcast is fearful, but we sued them once before and reached a settlement. And I say, if we have to do it again, well, so be it. I like to avoid litigation, but I don't want anybody to rob me. So as Trustee Steiger said, we want reliable service at reasonable rates, and we need to negotiate whatever we need to do to get that out of Comcast and its successors.
All right, thank you. I'd like to move on to 13D. Thank you very much, gentlemen.
Just like to take a few minutes of your time, 3 in fact, to discuss the state law involving transfer of cable franchises. Act 480, and I understand not everybody in this room is a fan of Act 480, but it is the state statute, it is the law of the land. Act 480 specifically governs how transfers are to occur. And pursuant to Act 480, Section 3, Subpart 4, a uniform franchise or an existing franchise are fully transferable without action by local authorities. And the only thing that the cable provider needs to do is provide 15 days notice after the completion of the transfer. And just to be perfectly clear, no court has ever enjoined or ruled that that provision of Act 480 is unconstitutional or preempted by the Federal Cable Act. Now, unlike the PEG litigation, there's a specific provision in the Federal Cable Act that deals with PEG, and that's what the court hung its hat on in the Meridian Dearborn litigation, saying, well, this provision in the federal law preempts Act 480's provisions on PEG. Now, if you look at the Federal Cable Act, there is no similar provision relating to transfers. So there won't be any ability for the federal court to find preemption in this instance. And with respect to the Dearborn litigation, there were two other courts that had two cases very similar, virtually identical fact patterns after the Dearborn case was filed. One was heard by Judge Ludington, who also sits on the Eastern District, and it involved a different set of communities and a different provider. But in that instance, Judge Ludington did not follow the decision of Judge Roberts in the Dearborn case, did not find that persuasive. Similarly, there was a court in the Eastern District of, the Middle District of Florida, the St. Petersburg case, where the court just recognized the Dearborn decision was issued but refused to follow it. In addition, with respect to the what Meridian gained out of the litigation, it related to the you got analog PEG channels until you only got really three things: analog PEG channels, you received channel location, and then the final thing in the settlement was that Comcast would continue to provide the PEG transport for 2 years. Now, this PEG transport has always been provided by my client as a good corporate citizen. It is not a requirement in the franchise. It's not a requirement that's being imposed on any other provider. We've been providing it historically. We provided it since the 2005 franchise, but they're doing it as good citizens. It's not being imposed by a franchise. So when we agreed in the Dearborn litigation to continue to provide it for 2 years, we were just giving the proverbial sleeves off our vest. It was something we were willing to do to be good corporate citizens, and we only had to do it for 2 years. That has long since expired, and we continue to do it. So really, the notion that the PEG litigation resulted in some big windfall for the township, I don't really understand that, because the main thing they claimed they got, was something we always offered.
All right, thank you. I'd like to go on to Leslie Brogan. Thank you very much.
Good evening. Thank you very much for giving us this opportunity. I'm Leslie Brogan. I'm both a resident of Meridian Township, and I'm also a Senior Director of Government Affairs for Comcast. So, thank you. We've been talking a lot about Public Act 480 and who likes it and who doesn't. But I will tell you that despite where we come down on who likes it or who doesn't, we all abide by it. It was passed by the Michigan legislature. It opened up the gates for more competition. More competition came in, and this very township board awarded a uniform franchise to AT&T. That sets the stage for a level playing field. But what we're hearing tonight is a desire to impose conditions and obligations on us that are way beyond what were imposed on our competitor. And your consultants have said that it's very common to combine transfer and renewal issues while we're doing a transfer. Well, that's not what we're seeing here in Michigan. Meridian is one of 2 communities that are trying to utilize this to gain concessions over what our competitors are having to do. So we were very heartened by what the Cable Commission decided, and that was to stick conditions for a transfer with the transfer and deal with renewal issues later. And we find that that's the processes set out by law, and that's what we hope Meridian Township will operate under. What we do here in Meridian is voluntary. We do not have to carry your peg channels for no fees. We do not have to provide courtesy services to your schools, your libraries, your police department, your fire department, your peg insertion points. But we do that because we have chosen to do that voluntarily. There was also a question of, I heard your consultant say, well, when a new company comes in, what franchise are they going to be operating under? Well, they're operating under exactly what we're operating under now. And the renewal will take place after the transfer, just because of a timing issue. So I want to leave that with you, that this is a competitive cable environment, and we hope that you will treat us as you do our other competitors. Thank you.
Thank you.
Less than 3 minutes. As a volunteer and as a resident of Meridian Township, 4114 Spinnaker Lane, Okemos, in the middle of the Shoals. I just want to say I have the pleasure and honor of serving on the Cable Communication Commission, and we did spend a considerable amount of time today trying to get it right. We know that you have a lot of heavy lifting to do in consideration. My concern earlier, which led to me to ask for a moment to speak, was only about a matter of integrity, not a matter of doing the right thing, not that definition, a matter of why we're doing what we're doing, why we said keep the matters renewal and transfer separate. In simple terms, we'll say because it's very complicated. If you sit in that room and you're not a lawyer and you have a regular day job and maybe even go to conferences where you go to breakout sessions and someone's elected scribe, you know, you'd hope that somebody who's elected scribe would have the integrity to carry forward the sum of what was discussed in the breakout. You know, that we all know that doesn't happen very often. And I just wanted to happen tonight. I want you to realize that there's separate issues, transfer and renewal. If we keep them separate, we can work on conditions and we can find good solutions for township residents. That's all I wanted to say.
Thank you.